Good morning. Can everybody hear me? Everybody good? Good morning. How's everybody? Welcome to the first ever virtual Judd B committee hearing. We're going to hopefully move right along. Hopefully everybody's seen the agenda. And I'm going to skip around like I always do because that's what I like to do. But we're going to skip some and take them up tomorrow because they're not quite ready yet. But if everybody's ready, I'll call the meeting to order. First thing we're going to take up is House Bill number 796. Many of you remember that's the habitual offender bill that we passed last year, the exact same bill. It has a 15-year look back on crimes that are committed. The habitual offender can't attach unless it's within that 15-year period. There's a 15-year that runs from either the date that the person was released from the penitentiary or from conviction if they didn't serve. Again, the issue here is people who may have some type of drug crime, but in their past they have a violent offense, and then they would have to serve life. I've told you the story that happened up in my district. So the other part of this bill is making a trigger where the current offense has to be a crime of violence in order to get life. Now, you can still get habitual and still be sentenced to habitual under the little habitual provision, but in order to get life, you have to have that trigger of a instant offense being a violent offense. So that's the explanation of the bill. I'll yield to any questions if you guys have any. If not, title sufficient, do pass.
Mr. Chairman,
Yeah,
this is Sonia.
Okay, ladies
Okay.
recognized.
Okay, I couldn't hear you that well, but which bill are we on?
We're on 796,
Okay.
lady. That was the
Okay.
habitual offender bill, the same one we passed last year, basically requiring that life isn't given until there's a violent offense on the instant offense. Are there any other questions? All right, title sufficient, do pass. All those in favor? Okay, y'all unmute and say aye, or I tell you what, let's do it let's try this. If you're opposed to it, say aye or raise your hand. Okay. All I see is two. So motion passes. Motion to reconsider, gentleman from Rankin. Passes. Motion to table, gentleman from Wayne. Okay, next bill is, I'm going to recognize Vice Chairman to handle House Bill number 351.
Thank you, Mr. Chairman. 351 has several parts related to law enforcement, and I'll go through those section by section. The first section would provide for a $1,200 supplemental pay to officers who are employed by an accredited law enforcement department, which is where the department goes through extra training. And it's priced currently at about $4 million. If you turn over to section 4, that's on page 3, it would create a bulletproof vest revolving fund, which would be new. That would provide departments, sheriffs and police departments with the ability to use these funds as matching funds for a federal grant, which is available right now through the Department of Justice, to pull down those funds and purchase new bulletproof vests. Right now, there are many of the smaller departments in the state have no bulletproof vests at all. And many of the ones who do have them, they're out of warranty after 5 years. The revolving fund would be on a rotating basis. So the first year would be reserved for those departments that serve fewer than 15,000, whether that's in your city or your county. The second year would be reserved for those under 50,000, and the third year would be reserved for those over 50,000. If you'll go to section 5 on page 4, this concerns the Board on Law Enforcement Officer Standards and Training. It would add a member. If you'll turn over to page 6, line 138, there's already 2 members that are police chiefs, but this would add the president of the Mississippi Association of Chiefs of Police, and then he would have the president of that would appoint a chief of police of a municipality. So it would add 1 member there. And then if you'll go to page 8, section 6, this deals with university police departments. This would allow them to enter into interlocal agreements with the county sheriff's department or the city police department where the university is, and they would be able to share responsibilities or answer calls that are within the city or the county where the university's property is, if it is determined that there's an impact on students, faculty, or staff. Okay, but that just it doesn't force them to or require them to. It just allows them to enter into agreements with those entities that are already there. If you go to section 7, this is on page 9. This would create the crime of reckless endangerment, which many places already have, but this would create a misdemeanor and a felony. The misdemeanor would be engaging in conduct that places another person in imminent danger or death of serious bodily injury while not using a deadly weapon. The felony would be when using a deadly weapon. The misdemeanor would be punishable by up to $500 fine or 6 months. Felony up to $2,000 or up to 2 years. And that is an explanation of 351, Mr. Chairman.
Thank you, gentlemen. Are there any questions for the gentleman? Seeing none, gentlemen, what is your motion?
Title sedition do pass.
All right. All those in favor? Let's go back, I guess. Wait, are there any opposed? I see one. Seeing that, motion carries. Title sufficient do pass. Motion to reconsider, gentleman from Rankin. Motion to table, gentleman from Wayne. That one's gone. Mr. Vice Chairman, while you're recognized, handle the next one that you have, I guess, is House Bill 350.
Thank you, Mr. Chairman. House Bill 350 is in regard to the certificate of rehabilitation, which is where someone who has lost their right to have a firearm can get that right restored if they've gotten their life back on track. We passed this last year. It was, I think I would say it was uncontroversial for the most part, but it didn't come out of the Senate. All this does, this is already in law for people who are convicted of a crime in Mississippi. This would allow people who are convicted of federal crimes or of crimes in other states to apply for a certificate of rehabilitation in Mississippi by going to the court in their county of residence. They can't go back, to their county in Alabama and that be recognized in Mississippi, but they can go to the court where they live and apply for a certificate of rehabilitation. And that is a description of that bill.
Are there any questions for the gentleman? Again, gentlemen, this was the same bill that we passed last year, I believe. I think it was, like you said, non-controversial. Or is there anyone opposed? All right, seeing none, motion carries. Title sufficient do pass. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. That one's gone. All right, we're going to go to some of the other ones. Mr. Let's see. Gentleman from Pearl River, if you would handle House Bill 122, which I believe is a committee sub.
Thank you, Mr. Chairman. House Bill 122 would amend the expungement statute. It would permit an individual petitioner to obtain up to 3 felony expungements as long as it has been 15 years since the last conviction. And then the usual expungement process would apply. The petitioner would have to file a petition with the court, serve the district attorney, and give the DA plenty of notice. A hearing will be held, and the petitioner would have to prove that he has been rehabilitated and is a good member of society before the judge would grant. And that is a brief explanation of the bill.
Are there any questions? Gentlemen, is this the same bill last year that was vetoed by the governor? No,
sir. This bill is different. It's a little bit more, I guess, it's not as broad as the bill we passed last year. It provides that 15-year gap, and it addresses the governor's concerns. That's one thing I forgot to mention. It also addresses the governor's concerns about the discrepancy between the misdemeanors and the felony expungements.
Gentlemen, this is the committee sub, not the bill. Is that correct?
That's correct.
That's what we're on, is the committee sub, ladies and gentlemen. So what is your motion?
Title sufficient to pass, I believe, as amended.
Committee sub.
Committee sub.
Title sufficient do pass, committee sub. Are there any opposed? Seeing none, motion carries. Okay, seeing one, motion carries. Lady from Pearl River, is that a question or just a vote?
That's a no vote.
Okay, no problem.
Thank you, sir.
Gentleman from, motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. That one's gone. Thank you, gentlemen. All right, the next, Rob, or gentleman from Oktibbeha is not on. He had the next two. I'll try to do them. The first one is House Bill number 119. Some of you may remember this was this is just extending a repealer on the Harper Grace law that we passed, I want to say 5 or 6 years ago, that allowed for a CDB oil prescription to come through UMMC. And this is just the extending the repealer of that program, allowing them to still administer the program. And that's best I can recall from that bill. Are there any questions? All right, anyone opposed? Title sufficient do pass. Motion carries. Motion to reconsider, gentleman from Rankin. Motion to table, gentleman from Wayne. That one's gone. Next one Rob has. Ladies and gentlemen, last year we passed this bill. It got kind of caught up with everything with as we all know how the session went last year. This is House Bill 615, DUI suspension. We're not really focused on the substance here. What we're trying to do is get people their license back after they get a DUI, because there's some, as lawyers, we have trouble communicating when we can tell our clients that they get their license back. That's the substance of the bill. What I'm doing is going to put a reverse repealer in this. So that's going to be the amendment to put a reverse repealer. This is the entire DUI statute that is open. And we're going to use this to travel through the process to, I always like to keep a DUI statute, expungement statute, and some of these things open if we need it going through the process. So that's what this bill will do, is reverse repealer, intend on it for going through the process and making changes. For one thing, I'd like to just to tell the committee where I'm looking at going. I'd like to kind of not make the interlock device mandatory and allow people to have a hardship license back so that they can drive. I would like to look back on some of the fourth offense DUIs and maybe have a kind of like what we did with the habitual offender, do away with put a time limit in there on those type of prosecutions, and some stuff like that, and basically being smarter with DUIs instead of just as stern as some of the stuff that we've done. But in any event, there's a reverse repealer in this. We're going to kick it along in the process. Do you have any questions? All right, seeing none. Anybody opposed? All right, motion title sufficient do pass as amended. So that motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. That one's gone. Okay, let's go back to front page, House Bill number 797. Yeah. All right, the rest of these are mine, maybe. 797 came to us from the prosecutors. This is one of their top priority bills. It basically removes, this is the committee sub. I just got these. I'll explain the committee sub to you. I don't know that y'all have a copy of it. I'll explain it. House Bill 797, sexual battery, removes the statute of limitation for sexual prosecution. Basically, there right now is a current prosecution for those. The prosecutors are, because of the nature of the crime, and I agree with them on this, it takes a while sometimes for people to come forward or for a victim to identify somebody. So the prosecutors want this to be able to prosecute some sexual offense crimes going forward. Like I said, this is one of their number one priority bills. The committee sub, what the committee sub does is it creates a new, some of you may remember the floor fight we had. This divides my circuit district, and the first circuit district court up in Northeast Mississippi. It creates two new districts, one in the north, one in the south, creating a district with Alcorn, Prentiss, Tishomingo counties, one district. Then it creates a district with Lee, Pontotoc, Etowamba, and Monroe into that district. It creates a new DA, and that there's going to be a bill later on for some of you to understand to pay for this split. That will come tomorrow, and what I will call one of the most important bills that this committee will do, and that's House Bill 289, which has a lot of stuff that we're going to help with our law enforcement officers in doing. So that's an explanation of the bill. Are there any questions? Okay, seeing none, anyone opposed? All right, motion is title sufficient to pass. Yeah, I'm trying to think if I want to put reverse repealer. I'm going to amend it even further. I think I'm going to put a reverse repealer in this, guys. So the motion is title sufficient to pass, committee sub as amended. All those in favor? Anyone opposed? All right, that one is motion to reconsider. Gentleman from Tibbahall, glad to see you. Motion to table. Gentleman from Wayne. That's okay, gentlemen. I know Tibbahall is just a land that just everything kind of just sucks you in, and you can't. I mean, it's just it's a horrible place. I get it. Hey, you're muted, and that's a good thing.
That's God's country, sir.
Okay, and for you that just joined us, gentlemen from October Hall, I took up your 2 bills, so they're gone and they're good to go. Okay. Hey, gentlemen from October Hall, still didn't hear you. Turn up the volume on your phone or whatever you got. Let's try that. No, sir. Hey, Benjamin, is there? Hey, gentlemen from October Hall, I don't know why we can't hear you, but if you have a question or something, you can chat. I'm being told. So I know you like to. I know you're chatty. All right, let's move right along. Next bill is House Bill number 799. Again, this is the prosecutor's bill. This is terroristic threats. We passed it out of committee. It ended up dying last year. They're having some issue prosecuting people because the way that the bill is, and let me get to it, 799. All the bill itself does is removes a language that if there is a terroristic threat made, the person, as current law, if there is a terroristic threat, the elements of the crime is they have to intimidate, coerce a civilian population, and cede to their demands, influence or affect by intimidation, and cede to the demand. We're removing that language that they must cede to the demand. So prosecutors are having some issues with this, and I told them that we would address that. And ladies and gentlemen, this is the committee sub 2. And the committee sub likewise is just like the other one. It has my judicial split in it as well. And ladies and gentlemen, I would offer an amendment to have a reverse repealer in it as well. So the motion is title sufficient do pass committee sub as amended. Are there any questions? All right, seeing none, anyone opposed? All right, that motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. That one is gone. All right, House Bill 70, and some of you have asked me about this one regarding, this comes to us from a mom, I guess, from Meridian, who some of you seen the story on 48 Hours and on listen to a podcast that I'm told is out there. This is an autopsy bill, basically providing for confidentiality of these autopsies, not letting them be released for general disbursement, general distribution among the public, whether it be social media, websites, whatever the case may be. It provides for confidentiality of those. I'm going to offer a conceptual amendment to this and I have language in my office. Basically, what the amendment says is I don't want to infringe upon the use of these autopsies for education purposes, for someone using it in investigation, or a doctor who might use this to teach with that. So we're going to conceptually, and I have some language to add that exceptions in there, but for the most part, the purpose of this is keeping these confidential and not letting them be distributed out to the public, so that a family will have to look at, for all time and purposes, on the internet at their loved ones' autopsy photos. So any questions from anyone? All right, motion is title sufficient do pass as amended. Is that as title sufficient do pass as amended. Anyone opposed? All right. Motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. Ladies and gentlemen, next one is House Bill 80. This is the dog bill. Again, comes to me from my prosecutors up in my district. And I'll tell you the foundation of this. We had a young lady who was mauled and mutilated from a attack of a dog. I'm not sure what kind it was. That's irrelevant. But it was a dog who had a propensity and who had been determined to be a vicious dog. And so what my prosecutor's telling me is that they really don't have anything on the books to prosecute it. And for those of you who do criminal defense, the individual has now been indicted under aggravated assault, which frankly was the only statute they thought they had. And I think that is kind of a weak statute for them to do. But be that as it may, this creates a crime that, and I think we got this law out of, we merged a couple of states that have a similar effect. It creates a new series of offenses, both misdemeanor and felony, and a civil action against the owner if this happens. Now, keep in mind, the intent of this is the dog has to be have a propensity and or a history of biting and been found by a court of competent jurisdiction that it is a vicious dog. So we're not just talking about any run-of-the-mill dog. There has to be a situation and some type of culpable negligence there on the owner's part. It creates, if for example, the dog has been adjudicated one of these things, or it has a propensity, there is a misdemeanor fine that could be imposed for the escape of the dog. There's also a felony that comes into effect if there's a biting situation. That felony increases, sort of like our DUI or domestic violence statute, stacks by offenses. So the penalties get harsher as more instances happen. The initial felony is a maximum $5,000 fine with a 3-year incarceration time. It goes up to, every felony after that goes up 5 years to 5 years with a $10,000 fine. And then after 2, it could be up to a 10-year in the prison. If there is a severe mutilation, like in the case of my girl back home, it could be a penalty up until, let me say, a severe mutilation and or death, it could be a penalty of up to 5 to 25 years. And the dog may be confined by law enforcement or city officials there. And like I said, it creates a civil penalty, which I think is already available, but a civil penalty under the statute. So that's an explanation of the bill. I'll answer any questions if there are any. Lady from Pearl River, you're recognized.
This doesn't have anything to do with the breeds of dogs, correct? It's just typically the biting and the penalties, correct?
That's correct. No specific breed is identified by this bill.
Okay, thank you, gentlemen.
Any other questions? All right, motion is title sufficient, do pass. All those in favor? All those opposed? Gentleman from Jackson, let me redo that. All those opposed? Okay. All right, I see 1. Motion carries. 2, okay. Motion carries. Title sufficient, do pass. Motion to reconsider. Gentleman from Rankin. Motion to table. Gentleman from Oktibbeha. All right, that one is gone. Y'all give me your indulgence just 1 second. All right, ladies and gentlemen, we've done good work. One bill left, House Bill number 287. This is the drug intervention courts. This is a lot of cleanup language in this bill. It just brings up, some of you are now aware, we have both drug courts, mental health courts, veteran courts. The original statute just mentions intervention courts. This is kind of distinguishing and basically adding the word, whether it's a drug court, whether it's a mental health court, whether it's a veterans court. So it cleans that up. It brings it up to some of the national standards, like research-based program, using some research-based, evidence-based type of subjects to that they use in the drug program, that they use in the drug court program. Also, it also prevents some, it also cleans up some language about who can and cannot come into the program. So this comes to us by AOC saying that this is stuff that AOC, being the administration office of the courts across the hall or across the street at the Supreme Court, they're asking for some cleanup language. Also, I'm going to offer an amendment on this as well. Gwinnetta, I'm going to, again, put the code sections are in this, and I'm going to put this in here to, again, split my circuit district with this bill. So, yes, same one. Mm-hmm. So that would be the same committee subs we passed, and we're putting those into this bill. And let's put a reverse repeater in it too, Gwinnetta. So that is the essence of what we're doing here. We're going to do it as a committee sub? Be so big? Okay. So it would be committee sub as amended, or with the reverse repeater still? So you can do it, okay, all right. Okay, so the motion is title sufficient, do pass committee sub. Any opposed? All right, seeing none. The motion carries. Gentleman from Rankin, motion to reconsider. Gentleman from Wayne, motion to table. All right, ladies and gentlemen, we're going to meet again tomorrow at 8:30. We've got some other stuff that we're going to take up. I will try to have you an agenda out as soon as I get here in the morning. I don't know what that is at this point, but did everyone have access to that agenda before you got on today? It should have been emailed. I think whatever it is, we'll email it to you. And as such, this committee is adjourned. Thank you, guys.
Nick, can you hear me now?
Yeah, unfortunately.
I'm sorry. I've just had problems this morning with this computer.
That's okay. We understand.
See you in the morning.